When it comes to legal disputes, there are a variety of remedies available to the parties involved. In civil cases, these remedies can be categorized into two main types: monetary and equitable. Monetary remedies can take on several forms, including compensatory damages, exemplary damages, liquidated damages, and nominal damages. Compensatory damages are designed to provide financial compensation to the party who was harmed in the dispute. The court may also choose to award court costs and attorney fees to the prevailing party. Exemplary damages, also known as punitive damages, are awarded in cases where the defendant's behavior was particularly egregious. These damages are meant to punish the defendant for their actions and to serve as a deterrent to others. Liquidated damages are established by either a court judgment or a contract stipulation and are intended to compensate for losses or injuries resulting from a breach of contract. This type of damages is typically included in contracts involving the exchange of money or the promise of performance. Nominal damages are awarded in cases where a legal wrong has occurred, but there was no actual financial loss resulting from that wrong. In these cases, the plaintiff is typically awarded a small sum, such as $1 or $2. Overall, the goal of monetary remedies is to provide compensation to the injured party while also ensuring that the responsible party is held accountable for their actions. Whether through compensatory damages, exemplary damages, liquidated damages, or nominal damages, the court has a range of options. Let's get into the nitty-gritty of judicial remedies. So, we already talked about monetary remedies, but there's also another type called equitable remedies, which are all about what's right and fair. One example is specific performance, where the court orders a party to carry out a contract exactly as it was agreed upon. This is different from just giving money for damages. Specific performance gives the plaintiff exactly what they bargained for in the contract. Then there's rescission, which is when both parties agree to cancel the contract and any money that was given is returned. This usually happens when the contract becomes impossible to perform for some reason. Finally, there's reformation. This is when a court orders a change to an existing document because it doesn't conform to what the parties originally agreed upon, either due to mistake or fraud. This ensures that the parties' agreement is upheld and justice is served. Overall, these remedies are all about fairness and making sure everyone gets what they deserve. It's not always about money, sometimes, it's about doing what's right. That's all for now, y'all. Stay righteous. So, let me break down some important points for you regarding judicial remedies in a really cool and calm way. First off, we have the injunction remedy. This remedy is basically a court order that requires a party to either do or not do specific actions. If someone fails to comply with an injunction, they can face serious consequences like criminal or civil penalties, monetary sanctions, or even imprisonment. Next up, we have foreclosure. This is an action that seeks to terminate someone's interest in a property. It's usually brought on by a lien holder, such as a lender or someone who holds a mechanic's lien on a property. Moving on, we have quiet title. This is a legal action that's taken to determine who holds ownership in a parcel of real property. It's used to give an owner clear title to a property or to remove any uncertainty or disputes about the ownership of the property. Finally, we have declaratory relief action. This is when a court determines the rights of parties involved without necessarily ordering anything to be done or awarding damages. It's used to get an official declaration of the status of a matter in controversy. For example, a party to a contract may seek the legal interpretation of a contract to determine the party's rights. Hope that helps. When two parties are in a dispute, most of the time they settle the issue outside of court. It's called non-judicial remedies, and it can save time and money for everyone involved. They use alternative dispute resolution, ADR, which involves private approaches to resolving disputes. It's encouraged and even required in some cases by federal and state laws. Now, there are two main methods of ADR, mediation and arbitration. Mediation involves a neutral third party called a mediator, who listens to both sides and helps them come to a compromise. It's used a lot in settling labor disputes and consumer complaints. But if the parties can't come to an agreement, then they can try arbitration. Arbitration is like a shorter, less expensive version of a court trial. Both sides can present their evidence and arguments, but it's more informal. An arbitrator, who is also a neutral third party, makes the final decision that's binding. Arbitration is usually required in contracts or by law, like in cases of medical malpractice. And let me tell you, once an arbitration decision is made, there's only a few limited reasons to appeal it. So it's less likely to get reversed than a court judgment. That's why arbitration clauses are often included in business contracts. It saves time, money, and promotes less hostile relations than litigation. Plus, it allows experts to handle complex issues.